Start करते हैं. Hello everyone. So today I am going to discuss a very interesting subject, that is constitutional law, and primarily I will be focusing that how to study constitutional law, right? So rather than going into nitty-gritty, I will be trying to decipher that from which portion we have maximum number of questions and where you should focus more. Okay, so if you are a new law student, if you are trying to prepare initially, then also this video will be helpful for you. And if you are already have studied law, then these portion actually you can give more weightage to. Now if you look at the constitutional law, primarily it covers all the topics of constitution, right? But there are some of the topics which is not there in the syllabus itself, but they have asked question from it. Okay, so when if directly it is not given, indirectly the questions have been asked, right? Now if you look at the whole syllabus, right, you will find that there are 5 major areas from where you have maximum number of questions, right? The first major area is your fundamental right. Now you must have seen there are a lot of topic in the fundamental right, almost whole of part 3, but you will see that within the fundamental right also there are some of the area where you can find the maximum number of question, right? Like the trioca of rights. So do read article 14, 19 and 21. Okay, so that particular 3 rights has to be studied in great detail. Okay, recently you must have seen the questions on the basis of fundamental right, apart from this article, comes from right to freedom of religion. There have been Supreme Court cases, right, recently quite in news. So if you are going to appear for exam this year or the next year, right, so definitely you should give extra time while studying these 2 articles, right, these 2 set of articles actually. Now third type of question that comes from fundamental right is basically philosophical in nature. Now the philosophical type of fundamental right question only comes from article 14 and article 21, right? If you look at the recent trend, it means the 90% of the time, right? And the basic point beyond the philosophical type of question in the fundamental right is that how its interpretation have changed in different decades, right? Different decades, how the interpretation have changed. Okay, so I am not going into much detail, but I will give you a very basic that in initial decade when the constitution was enacted, the fundamental right was interpreted as a container box. They are not connected with each other, right? Now as the decade progressed, the connection was started to get established, and that too between each fundamental right, like right to equality, article 14, article 15 and 16, right? Between different categories of fundamental right, it was not there. Okay. Now when further the decade progressed, we will see after liberalization 1991, then there have been interpretation where both the set of fundamental right were started to be read together, meaning right to equality was started to be read with right to freedom of speech and expression. Understood? So that was the liberal approach that was adopted in the later years. Initially container, then fundamental right within one category relationship, then the fundamental right between different categories of relationship. Understood? Okay. So these are the progressive interpretation that took place. Now that is a matter of another lecture, that how this interpretation, how it affected and what are the major case laws in the constitution. Now the second topic that you should focus more in the constitutional law is basically your legislative and executive framework. Legislative and executive framework, both at union and at state. Okay. So this particular topic, it means it covers 2 things, the legislature and the executive at union and state level. Okay. Now if you look at these 2 topics in detail, you will find one thing very interesting here, that the questions are often mixed. right? Mixed meaning you will find very randomly, very less chances there that there is a direct question, okay, comment on the function of parliament. No, not at all. Or comment on the structure of the state legislature, not at all, right? They always try to mix the legislative function with the executive function, right? If you are a student of law, you must be aware that the executive function in India is interdependent with the legislative function. It means the extension of the executive function goes along with the extension of the legislative function. Constitution also it is written, right, that executive function will be as far as the union or the state have the authority to make law, right. So, if you have to determine the executive power of the union with regard to a particular subject, then you have to look at whether the union have power to make law on that subject or not. If the union have, then the executive function will extend, right. Obviously, there are certain if and buts to that, but obviously that will require detailed discussion. Okay. So, that is the first type of question that they ask, that is your interdependence between executive and legislative function, right, executive and legislative. Okay. Clear? Now, the second type of question, if you will look at the syllabus, is your relation to privileges, right. So, those privileges attached to legislature and its conflict with two things, fundamental right and privileges given over, or your privileges of court or contempt of court, not exactly privileges, contempt of court, right. So, that is the second type of question, right. They are trying to interact 2-3 topics together, fundamental right, contempt of court, yeah, judiciary, as well as finally your legislature. Okay. So, that is the second type of question that you will find mostly, right. The third type of question that they ask generally is your nature of legislature, in which we have this federalism, and executive, in which we have constitutional governance. Okay. So, this is the two topic that is connected together. One is your constitutional governance, right, and second is your federalism. So, always there is a question on federalism, right, and you must have seen the question on federalism are generally very, very philosophical in nature, right. What is the nature of Indian federalism, or Indian federalism is quasi-federal, it is not exactly federal. Okay. So, those type of questions. Okay. So, combine at least 7 to 8 topics together in this legislative and the executive framework when you study. Okay. They do not ask it separately. So, if you are studying structure is neatly arranged, you can easily cover these topic in a cohesive manner, right. Sometime when you study these topic differently, severally, you will find that when a question comes connecting these topics, you are unable to answer. Why? Because you have not studied in that aspect. Okay. So, that thing has to be kept in mind, right. The third topic from where a lot of question comes, right. Now, out of these 5 topics that I will be discussing, 80% of the question from the constitutional law will come. Obviously, there are exceptions sometime. Now, the third topic from where I would like you to study is your judiciary. Now, when we are talking about judiciary, then I am not talking about only the institutional structure, power and function of the judiciary, right. That is obviously the first part that you will study, institutional structure. Okay. That is the power of the Supreme Court, High Court, right, especially give more focus to 226 writ jurisdiction, right, appellate jurisdiction. Okay. And the structure of the Supreme Court, judge appointment, removal, right. So, in removal sometimes they ask philosophical question. The second option of the judiciary is basically problems that is with the judiciary, right, problems with the judiciary. Okay. So, what is the problem? There is a lot of caseload, right, delay in the judiciary, right. So, in that aspect multiple tribunals have been formed in India. You must have read also, there was a question last year also, tribunalization of the justice, right. So, those tribunals has to be studied along with it. Okay. Now, those tribunals not in literal sense, but how that tribunals have helped in solving the problem of judiciary, right, philosophically, rather than going directly into those nitty-gritty of the tribunal. Okay. So, you do not have to study that. The third thing attached with the judiciary, the problem is basically your alternate dispute resolution mechanism. However, we have a separate topic, but somehow it is connected to judiciary only. Okay, so we talk about section 89 of CPC and how it is important, right? Similarly, provision related to solve the delay of cases, provision related to establishment of Arbitration Council of India, right? That basically will lead to privatization of justice, right? So those things. The fourth topic that I will suggest you to read is constitutional institutions, right? Now, if you look at it, mainly the constitutional institutions they are talking about is actually UPSC, right? So I will request you to read all the topic related to UPSC. It means it will be also be covering civil servants, right? One question you can expect almost in every exam based on civil servant, right? The privileges that the civil servant have, especially in the case of removal, dismissal, or reduction in rank, okay, or what are the constitutional safeguard given to civil servants, right? So those topics has to be read comprehensively along with the UPSC itself, right? So bifurcating the preparation doesn't make any sense, right? So that topic you need to keep in mind, right? And the last topic that I would like you to study is basically your amendment. Now, they don't ask direct question from amendment at all, right? They must have asked 10 years before, but directly they don't ask you what is the procedure of amendment, right? So basically in amendment, but obviously you need to study about it, right? So the procedural part, and then you will go to directly what? The case laws related to amendment, right? Mainly Keshav Nanda Bharti doctrine. Okay, so as a law student, you should not only know the important case laws that you have a passing mention of, that you must have seen, must have studied also, right? But exact ratio that has been held down. Okay, like the best example I shall give you is, mostly people say that in Keshavanand Bharti, the majority held that the basic structure cannot be altered, right? But you will be very surprised that the minority also held that the basic structure cannot be altered at once. That is the critical point. It means that slowly it can be altered. Understood? Right? So that is the nuance that you have to write as a law student, which a non-law student might not want. Or obviously, even there is no need to write those answers for them. Understood? Okay. So if you cover these 5 topics in the constitutional law, right? So I'm very sure that 70 to 80% of the question, right? 5 topic connected with other topics, right? So that I have already discussed. So almost 80%, 70 to 80% question that comes in constitutional law, you can very easily cover, right? Now as to the books, obviously MP Jain is a famous book, but I suggest DD Basu. You can go for DD Basu. And in DD Basu, read all these chapters together, not individually, and try to make connections between themselves, right? Because the most of the question that comes, right, you must have seen that they are not direct, rather than it is in interconnection with 2 or 3 topics, right? Sometimes they simply ask you to define the topic itself. Okay, what do you mean by constitutional governance, right? Yeah, how the constitutional governance and the constitutionalism is connected, right? So those topics, right, those questions answer you cannot give once if you study the topics in isolation. It has to be connected with other topics. So while preparing constitutional law, keep these things in mind, right? Obviously, if you have any problem, so on defactolaw.in we have a total detailed analysis of this particular subject, that which part has to be covered, right, in a timely fashion. Okay, so that you can visit. Okay, thank you very much.